Good morning, everyone, and welcome to this procedural hearing. Let me begin by apologising to the lawyers present for the limited space available. I'm afraid that, as on the previous occasion, we thought it very important that we should have as much space available for members of the public, but particularly your clients, to ensure that they could actually be present in the room during the course of this hearing. Thank you all for your submissions, which I've read and found very helpful. I'm particularly grateful to those who represent the bereaved, survivors and residents for agreeing who should present which parts of their submissions. Of course, I have read and I shall reread all the written submissions which you've sent, but it's obviously very helpful to have each topic addressed only once. One of the things that struck me is that some of the points that have been raised in the written submissions have been overtaken to various degrees by discussions between the inquiry team and some of you over the last few weeks. To that extent, I would suggest that there's no need to spend time rehearsing submissions which have now been overtaken. The inquiry team has circulated a running order which allocates a time to each body or group of people who wish to address me. I'm sure you'll do your best to limit yourselves to the times suggested. As I've said, I've got the written submissions, and I'll be able to look at those again after the hearing. And of course, there'll be a transcript of this hearing, which I can also review. Just to remind you that, as on the previous occasion, the proceedings are being recorded. They're also being streamed live to other locations. For that reason, amongst others, when you're invited to speak, I'd be grateful if you'd come up to the reading desk here. It's necessary for you to do that in order to be seen on camera and for you to be recorded, as I say, both for the purposes of the streaming and for the purposes of the transcript. So we'll adopt the same procedure that we did on the previous occasion, which seemed to me to work quite well. I hope you felt the same. So with those few introductory remarks, I'm going to invite counsel to the inquiry, Mr. Richard Millett, Queen's Counsel, to open the proceedings.
Mr. Chairman, by way of introduction, what I'm going to do is to update the core participants, or CPs, as to the work of the inquiry since the last procedural hearing in mid-December 2017, and to set out the inquiry team's proposals to take us down to the start of the oral hearings for Phase 1. I start with representation. Present today, excluding me and the inquiry legal team, are some 12 counsel and solicitors' teams, representing a total of 28 organisations and governmental CPs, and 504 CPs who are bereaved, survivors and residents of Grenfell Tower, who I shall call BSRs. Some CPs are present and have not put in written submissions and who don't wish to address you. Some CPs are both present and have put in written submissions but don't wish to address you, either at all or at any length. Some CPs are neither present nor have put in any written submissions. Thames Water is a recently added CP who has put in no written submissions but may wish to address you. All CPs have an updated speaking list, which is correct as at Friday last. As at the December hearing, that speaking list is only for this procedural hearing number 2 and establishes no precedent. The reason that we have the Metropolitan Police here as the first CP to speak, as we also did at the December 2017 hearing, is so that they can provide a brief update on the criminal investigation. The CPs will then speak in 2 successive groups. First, those representing the BSRs, who have agreed to speak in the order G5, G11 and G3, each having agreed between themselves to cover separate topics. And second, the CPs who are organisations or government departments. In terms of total numbers of CPs in this inquiry, those currently with CP status are 128 CPs from bereaved families of the deceased, including one who currently has no legal representation. 209 CPs who were residents of Grenfell Tower or visitors at the time of the fire. 4 CP leaseholders who were not resident at the time of the fire. 163 CPs from the walkways, and 28 CPs who are organisations, including the TMO, the Council, and the MPS, Metropolitan Police Services, and various government departments. On the 20th of March 2018, the inquiry published a list of CPs with certain exceptions. To date, the chairman has granted core participant status to a total of 532 individuals and organisations. As I say, 504 are BSRs and 28 are organisations or government departments. Mr. Chairman, you received some 22 applications from core participants to have their names withheld from the list for a variety of personal reasons. Among the 22 CP applicants were 7 core CPs who asked to be allowed to remain anonymous throughout the inquiry's proceedings. You granted anonymity to 3 core participants whose names appear in the list as AAA, CCC, and DDD, and refused the applications of the other 4. Of the 16 who only asked for their names to be withheld from the list, you rejected 12 of their applications and deferred 4 pending the receipt of further information. You have published a ruling setting out the principles which you have applied in making these decisions. In addition to the documents on the inquiry's website, all CPs present here today have the following documents. First, our Council's statement dated the 12th of February 2018, the programme, and all other CP submissions which were circulated last Friday. I propose to do 2 things, Mr. Chairman. First, to update the CPs as to the inquiry's progress and speed of progress on numerous fronts. And second, to present and explain the detailed next steps, taking us down to the start of the oral hearings for Phase 1. In this opening address, I do not propose to provide answers to all the many points made in the various written submissions put in by CPs, but will wait instead to hear what further points are made to you during this hearing. Can I start with an update on assessors? First, tenant voice assessors. In addition to the 3 assessors who have been appointed to the inquiry, the chairman is currently considering a number of individuals with relevant expertise and experience in the field of social housing and tenants' rights to assist, in particular, with consideration of the issues from the tenant's perspective in relation to item 1E of the inquiry's terms of reference. The chairman has identified a group of potential candidates as tenant voice assessors, and they will be interviewed over the next few weeks from a shortlist. So far as architect assessors are concerned, the chairman is also considering a number of individuals from the field of architecture to assist with consideration of issues related to items 1B, 1C, and 1D of the inquiry's terms of reference, insofar as they relate to matters of design and the choice of materials for use in high-rise buildings. This assessor is required for Phase 2, and so there is less urgency. The inquiry is also looking at retaining an expert architect. Once these individuals have been appointed, CPs will be notified and details will be published on the inquiry's website. The inquiry continues actively to consider the requirement for further additional or supplemental expertise as the evidential picture develops. Second, position statements from CPs. Position statements were received from certain CPs during the course of February. These have now been disclosed to all CPs. Some position statements were provided with supporting documents. In some cases, redactions have been sought to some of those supporting documents. The inquiry team has had to consider carefully whether to disclose the documents with the redactions as applied by the relevant CP, or without the potential redactions, or else challenge the claimed redactions and obtain a ruling from you, Mr. Chairman, prior to disclosure to CPs generally. In the end, the inquiry has decided to disclose the documents containing the redactions for the time being, but will decide upon the appropriateness of the redactions with the relevant CP in slower time. We have also withheld 2 unredacted documents because redactions to them may be required, and we have been chasing a supporting document from RBKC, which has not yet been provided, and we will provide that as soon as we get it. Third, completion of Phase 1 document disclosure. The process of disclosure to CPs for the Phase 1 hearings commenced on the 19th of February and is continuing on a rolling basis. To date, 3 tranches of material have been disclosed to CPs and made available on the electronic workspaces. That material includes floor plans, photographs, and videos, including media taken on the night of the fire. It also includes a large amount of forensic material which is relevant to the cause and origin of the fire. As we previously explained, the Phase 1 disclosure will principally consist of primary evidential material relating to the events of the night. The vast majority of this has been provided to the inquiry by the Met. Although as much as possible of that primary material will be disclosed in advance of experts' reports, the process is affected by the MOU, or Memorandum of Understanding, that the inquiry has with the Met. In particular, the inquiry is required under the MOU to notify the Met of the intention to disclose that material and then follow the processes outlined in the MOU before disclosure to CPs generally can occur. Although the inquiry is making concerted efforts to engage with the Met in an effective and in an efficient way, the process is a complex one and can be time-consuming. That means that some primary evidential material will not be disclosed until close to or at the same time as the experts are disclosed at the end of this month. We are, I should say, very grateful to the Met for their great and continuing assistance and their cooperation with the inquiry over the release of Phase 1 documentary material for disclosure. In addition, the inquiry will also be disclosing a limited amount of Phase 1 material, which has come from third-party document providers other than the Met. This will be relevant, for example, to the physical state of the building on the night and includes key drawings and manuals relevant to its operation. Those who have provided those documents to the inquiry have recently been notified of the inquiry's intention to disclose these documents, and the redactions protocol that we have is being followed with those providers. Tight timetables are being imposed by the inquiry in that regard. At present, the inquiry team is not aware of any significant redaction issues which are likely to arise in respect of this documentation. For the avoidance of doubt, there is no question of material being held back until disclosure of inquiry experts' reports. As and when the inquiry has the relevant permission to disclose the material from the relevant document providers, it will be disclosed as soon as possible thereafter. In the case of the Met, this requires going through the processes, as I said, identified in the MOU, which can take additional time. Looking forward, the aim is that by the beginning of April, CPs should be in possession of the vast majority of the relevant material for Phase 1. At that stage, we intend then to do a reconciliation exercise, in particular to check whether there are any categories of further material to which we ought to be alerting CPs in the interests of transparency. That will also apply to the experts' reports in order to check whether there is any material which was provided to the experts, which has not been referred to in their Phase 1 reports, but which ought to be disclosed to the CPs at this stage. That exercise cannot sensibly be carried out until we have finalised the Phase 1 experts' reports and the associated disclosure which will accompany those reports. In terms of the format in which documents are disclosed, we have already taken steps to ensure that there is a field tree structure on the Relativity Electronic Documents platform for the Phase 1 disclosure, which gives useful subcategories. A letter about the folder structure and field tree, including guidance about accessing the field tree, will be provided to CPs. If any CPs are experiencing difficulty in this regard, then they should contact the inquiry team without delay. Fourthly, Phase 2 disclosure. The process of gathering and identifying relevant documents for Phase 2 is continuing in parallel with the Phase 1 disclosure exercise. To date, approximately 330,000 documents have been received from some 45 providers of documents. That number is continuing to rise week by week. We currently estimate that the inquiry will eventually receive over 400,000 documents. Out of the 330,000 documents so far received, a substantial number of documents are exactly matching duplicates and have been marked as such. Leaving aside duplicates, approximately 183,000 documents have now been through the first stage relevance review, with some 95,000 left to review. The inquiry continues to provide monthly bulletins to CPs about the disclosure process, and those will continue. In the February bulletin, the inquiry published a list of all document providers who have provided documents to the inquiry at that point. We are continuing to identify potentially relevant providers of documents as the inquiry's work progresses. The March disclosure bulletin is in preparation and will be circulated to CPs very shortly. Our current intention is that Phase 2 disclosure should take place on a rolling basis once proper and proportionate checks have been done for relevance to screen out genuinely duplicate documents. We anticipate that a significant volume of documentation will be disclosed at that stage. A number of CPs have queried whether the inquiry might be applying a test of relevance which is too restrictive. To avoid any doubt about this, we have instructed reviewers in our teams to take a broad approach to relevance, using the list of issues as a starting point. Where they have queries, those queries are referred to more senior counsel. The reviewer's work is then spot-checked by a more senior counsel. As a result, we are able to say with some confidence that our approach to relevance is not unduly restrictive. We are also retaining all documents on our system, so that if an issue arises at a later stage, we can go back and search through any documents which we have previously marked as irrelevant. Fifthly, firefighter statement disclosure. As you may be aware, Mr. Chairman, the process of taking written witness statements from the members of the LFB who attended the fire at Grenfell on the night has been undertaken by the Met as part of their criminal investigation. The Met has been disclosing statements to the inquiry pursuant to our MOU with them as and when they have been completed and signed. That process has been ongoing since November 2017. As at last Friday, the 16th of March, the inquiry has received in total some 415 statements in all, with 45 statements just confirmed this week as having been delivered. The inquiry team has been reviewing those witness statements on a rolling basis since they started coming in November. It may help if I explain in detail the process that we have been undertaking. Under the MOU with the Met, the inquiry cannot disclose any firefighter witness statement to any CP without first notifying the Met and giving them an opportunity to object on the grounds that such disclosure may prejudice their criminal investigation. It became clear early on to the inquiry that a large number of these statements are potentially relevant and should be disclosed to CPs. As the inquiry team's review progressed, we've been able to form an increasingly clear view as to which statements should be disclosed and which need not. On the 31st of January, to save time, we asked the Met for permission to effect blanket disclosure to all CPs of all firefighter witness statements. On the 9th of February, the Met refused our request and said they would only permit disclosure to CPs of any given statement after a review of each one by them for potentially prejudicial material. That was a process that would clearly take a long time. Accordingly, on the 13th of February, we provided a batch of 23 unquestionably relevant statements to the Met for their specific consideration. On the 20th of February, the Met accepted that some 16 of these could be disclosed without prejudicing the investigation. As to the remaining 7, on the 9th of March, the Met explained their objections, in part by detailed reference to certain highlighted passages in those 7 statements. They maintained their objections to disclosure, not only to the highlighted passages, but to the whole of each statement. They also helpfully indicated, however, that if the chairman still considered it appropriate to have these statements disclosed nonetheless, notwithstanding their objections, then they would respect that decision. The chairman, after consideration, took the view that it was hard to discern from the Met's letter or the highlighted parts of the statements what the offences might be that were being investigated or why disclosure to the CPs might prejudice the investigation or impede or compromise its integrity. Accordingly, on the 12th of March, the chairman decided that for the purposes of his conduct of this inquiry, the disclosure of these 7 firefighter statements would not impede or compromise the Met investigation. The firm view of the chairman and of the inquiry team is that not disclosing these relevant statements would certainly impede the inquiry. Over and above the initial 23 firefighter statements, a further 13 statements were notified to the Met on the 27th of February, and on the 12th of March, a further list of 85 statements was also notified. We are aiming to disclose those 121 firefighter statements to CPs via relativity as soon as possible, subject only to having the redactions completed by the LFB and checked by us, and provided that the Met do not raise any tenable objections under the MOU. The redactions are to remove sensitive personal information about the firefighters, such as personal health issues or private contact details, which would be potentially caught by the Data Protection Act. The process that we are now adopting, doing our best even still to accommodate the Met's concerns, is to identify rolling weekly batches of firefighter witness statements to the Met that we wish to disclose to CPs. And then the Met has up to 14 days in which to identify any objections to disclosure under paragraph 12 of the MOU, following which statements to which there is no tenable objection will then be disclosed. We have just this week sent a further list of 30 further relevant firefighter statements to the Met for disclosure pursuant to the MOU. We are continuing to receive firefighter statements from the Met, but we think we already have a sufficiently significant body of firefighter witness statements to enable us to begin phase 1 of this inquiry. The delay is regrettable, but it has arisen out of the inquiry's great desire to advance its own work, whilst at the same time taking care not to impede or prejudice the Met's separate investigation. That has required us to understand in full the basis of the Met's position that putting the firefighter witness evidence into the public domain would or may impede or prejudice its investigation. We are now satisfied that on what we know so far, it would not do so. Of course, if the Met can identify a tenable objection in relation to a particular firefighter statement or part of it, then of course we would consider that carefully, as we must. The Met has also required that the inquiry team carry out the necessary redactions to firefighter witness statements that are to be disclosed. There has been much discussion with the Met and the LFB about what is to be redacted. The Met have been concerned, understandably, that sensitive material should come out, or at least that families should be briefed first. This was always impracticable. The subject matter of this inquiry is itself sensitive, and the evidence is, in many instances, distressing. But it would be a failure of our public duty if the inquiry were to sanitize the evidence. Accordingly, what will be redacted from any relevant firefighter witness statement will only be material that by law must be redacted under the Data Protection Act. The redactions will be those effected by the LFB and double-checked by the inquiry. This also now follows the format agreed with the LFB for treatment of the firefighters' contemporaneous written notes, or Form 10s. There are 558 of those documents. They will be duly disclosed, redacted for DPA material, once the LFB and we complete the redactions process. And that process is very nearly completed. Following disclosure of the firefighter witness statements to the CPs, we propose to do the following. 1, we will select which statements we wish in due course to form part of the inquiry record, since not all those disclosed to CPs will necessarily be the evidence on which the inquiry's report is based. 2, of those firefighter statements which will enter the inquiry record in due course, we will decide which statement maker should be called to give oral evidence. In deciding which witnesses to call to give live evidence, the inquiry's general approach is that whether a particular witness is able to give detailed evidence which, in the opinion of the inquiry team, is directly relevant to one or more issues that will be subject to investigation by the inquiry. There will inevitably be some witnesses whose evidence, whilst relevant, may not further advance the inquiry's investigation. In those circumstances, particularly where the evidence will provide a useful degree of context, the inquiry will take that witness's statement, or the relevant parts of that statement, as read into the record. 3, once we have identified those statements as those which we would like to have in the record, we will notify CPs. We recognise that there may be firefighter statements which the inquiry has decided not to put into the record, but for which a particular case can be made to include it. We will remain open-minded about that. 4, once we have decided which firefighters we would like to call to give live evidence, we will approach them through the LFB, FBU, and the Met with a view to doing 3 things. First, liaising with them as to how they would wish to give their evidence. Secondly, programming in their attendance dates. And thirdly, if need be, arranging a familiarization visit to the hearing room. 5th, we would then publish to the CPs a list of those we intend to call with a provisional program of evidence. Again, we recognize that there may be firefighters whom the inquiry has decided not to call to give oral evidence, but for whom a particular case can be made to call them. And again, we will remain open-minded about that, subject always to practical and timing matters. 6th, as with all matters, final decisions about what goes into evidence lies with the inquiry. CPs will be aware that the most reliable evidence comes from witnesses who have not been prepped by their representatives or their employers. Indeed, we must draw all CPs' attention and their lawyers' attention to Section 35(2) of the Inquiries Act, which makes it a criminal offence, without the inquiry's consent, to distort or otherwise alter any evidence, document, or other thing that is given, produced, or provided to the inquiry panel, or to prevent any evidence, document, or other thing from being given, produced, or provided to the inquiry panel. The offence carries a prison sentence. The witness statements that come to the inquiry are their evidence, save to the extent that they add to it or they alter it in a public inquiry hearing. Of course, if a witness, firefighter or otherwise, wishes off their own bat to make a supplemental statement or correct their evidence in some way, then, as the chairman said at paragraph 34 of his 20th of December response, he or she is able to do that. And so far as they are firefighters, he or she should contact the Met. Sixth, 999 call production and disclosure. There are some 560 audio recordings of 999 calls which were made from the tower on the night by relatives and friends of those in the tower and by members of the public in the neighbouring area. That figure includes duplicate recordings. Although the majority of these calls were to the LFB, they include a small number that were handled by Surrey Fire and Rescue, Kent Fire and Rescue, and North West Fire Control. All these recordings have been disclosed to the inquiry by the Met. Onward disclosure of these audios to the CPs is subject to the MOU with the Met. These audio recordings have been transcribed by the LFB, and the written transcripts have been disclosed to the inquiry directly by the LFB. The inquiry team has been listening to each audio and checking them against the transcript and also for potential relevance. That exercise has allowed us to filter out recordings that are plainly of no relevance, such as those from passers-by who offer no particular insight into the progress of the fire. There are two particular aspects to disclosure of the 999 calls. First, production to the relevant BSR witness statement maker to assist them to make a statement for the inquiry. And second, wider cross-disclosure to the CPs generally. I take each in turn. First, production to individual BSRs who are making inquiry statements. The inquiry intends to provide the 999 audio recording of a call and the accompanying LFB transcript to, first of all, the BSR CP who is making an inquiry witness statement and who was the caller, and secondly, a BSR CP who is making an inquiry statement and who can be identified as present when the call was made and who heard the call. We will only provide the audios to the solicitors for the relevant witness where we have identified that person with a high degree of confidence. The purpose of the provision of the audio recording is so that the witness can refresh their memory of the call where this is relevant to their evidence. The witness may also be able to comment on any conversation with or by others or any background noise which can be heard on the recording. The inquiry expects that the witness will wish to quote from the transcript in their witness statement. If the solicitor for the witness considers that it would be useful to prepare a further transcript of the audio and exhibit it to the statement, then that would be most welcome. There would be need to have early discussion of the format of any such transcript. Once the audio has been used to produce the statement, then it must be returned safely to the inquiry. The inquiry has discussed this proposed course with the Met at length. It is fair to say that they are not able to agree disclosure of the audios to anybody but the identified caller. However, the inquiry sees no good reason why we should not proceed to disclose not only to a caller, but also a person who can be identified as present when the call was made and who heard the call and who is giving a statement. The inquiry considers that the steps that it will take when disclosing specific recordings to identified persons are sufficient to meet any concerns over sensitivity. The RLRs, solicitors for the BSRs, will already appreciate the sensitive and sometimes distressing nature of these recordings. Secondly, cross-disclosure of the 999 calls to all CPs. The inquiry team is firmly of the view that the recordings of the 999 calls on the night of the fire form an important body of contemporaneous evidence of what happened and to whom. We have yet to hear any cogent reason for not disclosing them, at least in transcript form at this stage, to all CPs. As to what goes into the inquiry record and in what form will be a matter for later decision. Members of the inquiry team have been listening to all the audios of the 999 calls. They have been comparing them to the transcripts and reviewing them for relevance. The transcripts are not all perfect. On occasion, there are mistranscriptions. Unsurprisingly, they do not record background noise or third-party conversations with another person physically present with the caller. These limitations do not, however, detract from the value of the transcripts as we look towards the Phase 1 hearing. The times of the calls are recorded on the transcripts. There are some which are highly illustrative or revealing of the conditions in the building at different levels at different times on the night. They also show what fire survival guidance, or FSG, was given, and on some occasions, when and to whom, or at least as to which flat or floor. There are some which do not reveal anything much beyond the pattern of fire survival guidance that was given and the nature of the response. But even they form a useful body of evidence from which general fact patterns can be derived. In order to disclose the transcripts of the 999 calls to all CPs as we would wish, the Met's position is that we formally need the consent or non-objection of the Met under the MOU, even though they came from the LFB. The inquiry gave notice on the 2nd of January that we wished to disclose the 999 transcripts. On the 29th of January, the Met responded and said they had no objection in principle, but as with the firefighter statements, they wanted to know which specific 999 transcripts we proposed to disclose and wanted to take a call-by-call approach. Again, this would be a cumbersome and immensely slow task. They also said that their position would depend on the sensitivity of the material, which is not a ground for objection under the MOU. We do understand the Met's concerns here. The material is indeed, in some cases, distressing. However, and at the risk of sounding insensitive, the subject matter of this inquiry is a mass fatality, and the contemporaneous evidence is, in part, distressing. But it cannot be sanitized. I should also add that we have had no representations from any RLR for any CP who is a BSR that we should clear in advance with their client the cross-disclosure of any 999 call and the relevant transcript. We have identified the audio recordings that we propose to disclose to specific witnesses who have indicated that they will provide a witness statement. Disclosure of those recordings to the relevant RLRs will begin shortly. That will be an ongoing process as individual CPs confirm that they will make an inquiry statement. As to the LFB transcripts, we have identified and are continuing to identify those which we consider to be relevant for disclosure, and they are now going through the inquiries, redactions, procedures, together with the LFB. As with the firefighter statements and the LFB Form 10s, the transcripts will be redacted for sensitive personal information caught by the Data Protection Act, but nothing else. Seventh, production and disclosure of BSR witness statements. As matters stand, we have now been informed by the RLRs for the BSRs that for some 135 BSRs, that they are ready and willing to provide witness statements for Phase 1. For those who gave police statements, and it is not all of them, some 112 Met packs have been collated from the Met's database, which was itself a lengthy and time-consuming exercise. 107 packs have been collected from the inquiry by the relevant RLRs, and 5 are here to be collected today. They comprise their police statements, their exhibits where these can be traced, and the CCTV images relating to them. These all relate to tower residents or people who escaped the tower on the night of the fire. We have prioritized the provision of MPS packs from tower residents because their evidence is likely to be the most relevant to the facts in Phase 1. This material is, in the inquiry's view, sufficient to enable those individuals to produce a witness statement for the inquiry covering the events of the night to which the Phase 1 issues relate. As CPs are aware, the Met required witnesses to provide their written consent for any police statement to be released to the inquiry. The Met provided a list of BSRs showing whether they have provided the requisite consent. There are still some 25 Tower resident CPs in this category who have confirmed through their RLRs that they do intend to give a witness statement, but who have yet to provide the consent. There are 10 Tower residents who have provided consent, where we are waiting for the Met to prepare the relevant packs. There are a further 34 Tower resident CPs who have not indicated whether they are intending to provide an inquiry statement. We would encourage their RLRs to bring us up to date with what their clients want, and we will obtain the packs from the Met. Many BSRs want to see their CCT images of them leaving the Tower. Those have been provided in the packs. As to the 999 calls, I have already explained that the audios will be provided, but only to the relevant caller or person present who have confirmed that they will give a Phase 1 statement to the inquiry. We have done an analysis which so far shows that at the moment we have identified 24 callers, of whom 4 have indicated that they are providing witness statements to the inquiry for Phase 1. As at today's date, we have not received any witness statements from any BSR, nor have we been given any update in the Council's written submissions as to when the inquiry might reasonably expect to see any statements. However, we have had very recent informal indications that many witness statements from BSRs will be produced to the inquiry by the 30th of March. We warmly welcome those indications, and we do look forward to receiving as many statements as can be done. But we will also urge each RLR to tell us as soon as possible where they are up to with each of their clients who is preparing a witness statement or who wishes to do so, what the difficulties are, and what the expected time frame is. As I will explain shortly, the BSRs have requested that the inquiry begin on the 21st of May with a period of memorialisation of the deceased, followed immediately by evidential openings. The Chairman is warmly in agreement with this timetable, provided it is adhered to. To make this timetable work, it is essential that the BSR's Phase 1 witness statements come to the inquiry as soon as possible. That is because they need to be considered and then disclosed to the other CPs. We then need to identify the witnesses we would seek to call to give oral evidence, program that evidence, meet the witnesses, familiarise them with the process, and ensure that we have appropriate arrangements in place for them to give evidence in the way that is most comfortable for them. The later the statements arrive, the less satisfactory will be our preparations. The less satisfactory our preparations, the greater the risk that a witness is overlooked or feels rushed or undermined. To repeat, there is a lot to do between receipt of a statement and the start of oral hearings. Eighthly, venue and arrangements for attendance. First, venue. A number of options were explored for the permanent venue, initially focusing on West London, but working outwards from there. We have researched over 150 venues. These included the suggestions made by CPs following the last procedural hearing: Olympia, Kensington and Chelsea College, and Newcomb House in Notting Hill Gate being examples. These were either unavailable for the period that we require or unsuitable for various different reasons. Holborn Bars was and remains the best available option, chosen after taking several factors into account. It is large, it is well provisioned enough for the operation of the inquiry, and for the accommodation of a reasonable number of those wishing to attend hearings. It has enough rooms to provide on-site the facilities that the BSRs have asked for. It will be available for the length of time that we are likely to require it, and it allows us to be a permanent fixture. Many of the local community options that we looked at would require us to take everything down at weekends, for example, so that the building could be used for other purposes. In addition to the hearing venue, the inquiry will ensure that its proceedings are widely accessible by streaming them online and providing a venue within the borough where residents and survivors can come together to watch the proceedings. Special arrangements for the giving of oral evidence by BSRs. It is not possible for the inquiry to be specific about what special arrangements will be needed until we know which of the BSR witnesses we intend to call. That depends on the provision by them of a witness statement to the inquiry, our deciding to call the maker, and a proper assessment by their RLR of their individual client and close liaison with the inquiry team. As to the range of specific measures, these are all set out at paragraph 12 of the inquiry's protocol on vulnerable witnesses. For such witnesses, there will be various options for giving live evidence, such as screens, live link, pre-recorded evidence, statement read, sitting or standing with the family or friends, and support organisation members if needed, a witness table, regular breaks, interpreters, and notices of questions through the inquiry team. So far as counselling is concerned, the inquiry is presently discussing the provision of support with the NHS's Grenfell outreach team and Hestia. Their outreach workers will be familiar to many BSRs, as they have supported at public meetings and community events since the fire. Outreach workers will be present and they will be visible at procedural hearings and also the screening at Notting Hill Community Church. They will provide direct support and signposting for attendees, and we will make private space here at Holborn Bars available for them to hold meetings. They're working on a joint proposal for the evidential hearings to ensure that attendees and witnesses have access to on-site counselling and support, bringing in other providers as appropriate. We expect this in April, and we will share these proposals with RLRs in due course. So far as travel and subsistence are concerned, we have agreed that we will pay a fixed daily amount for attending the hearings, which will more than cover reasonable travel and subsistence costs to get here from North Kensington. So far as concerns meeting the reasonable costs of attending meetings with their solicitors, we would meet those costs, but BSRs will need to claim those back through their solicitors, and we would pay them back as disbursements because we can't check them ourselves. We will meet loss of earnings expenses for those who attend as witnesses, but not for CPs who choose to attend the hearings other than to give evidence. The hearings will be live streamed online and to a local venue to encourage as wide participation as possible. Next, refreshment provisions suitable for all dietary demands. Again, this is difficult to do given the varying numbers of people who are likely to attend each day. There will be hot and cold drinks available here at Holborn Bars. There are plenty of places to purchase food in the area. As indicated, we have agreed that we will make a fixed daily payment that will cover the reasonable costs of a day and will allow attendees the widest possible choice in how to use it. So far as concerns childcare, we have been asked about the provision of childcare at inquiry events and provision for the cost of childcare to support meetings in relation to the inquiry, including meetings with their solicitors. We have discussed before the difficulties of providing childcare where we don't know what the specific task will be on any given day, but we would be willing to meet the costs incurred, and again, BSRs, RLRs, or solicitors will need to provide us with the evidence of those costs for us to reimburse them. So far as religious needs are concerned, we will be providing a dedicated prayer room here at Holborn Bars, as well as information about local places of worship. More generally, so far as concerns community engagement, the establishment of a community advisory group was proposed following the December procedural hearing as a way to strengthen and encourage further participation and build confidence in the work of the inquiry. The inquiry team has consulted with a number of groups, either representing or working with the BSRs, both those who are CPs and those who are not. Although there was some support for the idea, it is clear that the proposal does not command the overall confidence of the BSRs. The inquiry team will continue with its programme of community engagement to ensure that all those who wish to understand and participate in the work of the inquiry are able to do so. Should the views of local groups on the proposal for a community advisory group change or further ideas come forward, we should be happy to visit the proposal. Ninth, commemorations of the deceased. First of all, the way forward. The inquiry has always embraced the idea that its work should be as inclusive as possible, so far as consistent with its functions and the terms of reference. That extends to designing it in such a way as to offer an opportunity for those families who lost loved ones at Grenfell publicly to commemorate them as individuals, calmly and with dignity. This, we feel, can and should be done in a special period of hearings immediately prior to the start of our evidence hearings. CPs, and bereaved families in particular, may memorialise their loved ones in any way they think best, whether as a presentation, or as an audio recording, or a short video film, or in any other way. By starting the public hearings of this inquiry in this way, we can ensure that however technical and scientific the issues may then become, however dry, however legal, we will never lose sight of who our work is for and why we are doing it. Secondly, Article 2 and the inquest function. Many BSRs have submitted to the inquiry in their submissions that the chairman should take and discharge all the functions of the inquests in order to discharge the state's Article 2 obligations. First, it should be noted that the Chief Coroner has not actually asked us to do so. Secondly, the inquiry will carry out its terms of reference and seek to do so by reference to the detailed list of issues. To the extent that the issues cover all the matters that Article 2 requires, then the inquiry will adduce the relevant evidence and make the relevant findings. That will cover who died, where they died, when they died, and within the scope of the TOR, how they died, and the circumstances. We have carefully considered the written submissions prepared on this point by the BSRs. We have formed no final view on this point, and it would therefore be very useful to hear today from the BSR's representatives as to the precise practicalities of the inquiry discharging its terms of reference while also performing the coronial functions. Thirdly, in any event, on the question of promptness under Article 2, it would be unusual to expect the inquiry to fulfil the coronial function in full in advance of the police investigation, especially where the quality of the evidence relating to any systemic issues relevant to the criminal investigation is unlikely to degrade over time. Therefore, there would anyway be no lack of promptness or other failure to comply with Article 2 in the inquiry leaving to the coroner, likely post-criminal trial, if any, of those aspects of the circumstances surrounding the deaths that we do not cover. The combination of the criminal proceedings and the inquiry means that the promptness requirement is fully satisfied, and it is entirely legitimate for investigations to be phased under Articles 2 and 3, so that, for example, coronial proceedings await other investigations, including criminal proceedings. The case law makes it clear, Mr. Chairman, that not everything has to be done at once. Provided that the factual evidence is being gathered now, as it is, then other questions, for example, about the precise circumstances in which each individual came to meet their deaths, can occur at a later stage. 10th, disclosure of experts' reports and exhibits. Very good progress is being made in the preparation of experts' reports for Phase 1. We currently anticipate that reports from Colin Todd, Niamh Nick Dade, Luke Bisbee, and probably Barbara Lane will be served at the end of this month, and a Phase 1 report from Professor Jose Terrero will follow in April. As I have already explained, a significant amount of evidential material is likely to be disclosed at the same time that these expert reports are served and will be disclosed as supporting documents and listed as such in the relevant field tree on relativity. The experts have been instructed to ensure that all information which is relied on by them in their reports is cross-referenced and exhibited to those reports. Steps have been taken to try to ensure that relevant documentation is disclosed as soon as possible prior to that. Some of the material already disclosed to CPs will be relied upon by the experts in their reports. Given the processes which are necessary to follow under the MOU with the Met, it is simply not possible to disclose all material which will be relied on by the experts in advance of their reports being disclosed. That is because we do not anticipate resolving all of the outstanding disclosure issues which arise in respect of that material with the Met before the reports are ready to be disclosed. The processes for finalising experts' reports and liaising with the Met are therefore currently proceeding in parallel. As I've already mentioned, once the experts' reports are finalised, the inquiry team will check whether there is any material which has been provided to the experts but not relied upon by them, but which should be disclosed to the CPs, but which yet has not been. But that exercise can't be done until the experts' reports are finalised, and it's not practical or proportionate at this stage to list all the documentation provided to the experts, some of which will be relevant in any event to Phase 2 and not Phase 1. A number of queries have been raised about the scope of the experts' report at Phase 1. As to those, so far as Professor Neve Nick Dade is concerned, she will consider the primary evidence relating to the cause and spread of the fire in the compartment of origin, as well as reviewing the reports which were prepared for the Met on that topic. Insofar as the available evidence allows, Professor Nick Dade's report will provide a preliminary view on the issues of cause, origin, and spread of the initial fire within the compartment of origin. As to Professor Barbara Lane, her Phase 1 report will, where it is possible to do so, express a preliminary view about the extent to which the design and construction of the exterior of the building and the fire safety measures within the building were compliant with the relevant building regulations and other relevant guidance. See issues 4C, D, F, and 5B and D in the list of issues. We accept that these questions will implicitly arise when she is expressing a preliminary view on the active and passive fire safety measures at Grenfell Tower and the extent to which they failed to control the spread of fire and smoke and contributed to that spread. However, her report will not investigate the detailed factual circumstances as to how any instances of non-compliance came about. Those are more complex questions that will have to await further detailed work in Phase 2. The instructions to the 7 experts currently instructed by the inquiry were disclosed to the core participants on the 30th of November last year. More recently, 2 further experts have been instructed, and their written instructions and CVs have also been made available to CPs. Those experts are Mr. Rodney Hancock's. He has been instructed to provide a report for Phase 2 of the inquiry on issues relating to the gas supply to Grenfell Tower, including the compliance with the relevant regulatory framework of the gas supplies to and within the tower, and the steps taken by relevant parties to isolate the gas supplies on the night. He has also been asked to express an opinion on the extent to which the presence of gas in the tower contributed to the spread of fire and the conditions in the building on the night. Secondly, Dr. Ivan Stoyanov. He has been instructed to provide an opinion for Phase 2 on the supply of water to the tower, and in particular, the adequacy of the water pressure for the purposes of fighting the fire. The inquiry is also actively considering the appointment of other experts in key areas. These include, as I said before, an architectural expert and an expert in building control and inspection, and, as I've also said, in social housing management. We note that a number of BSR representatives have encouraged the inquiry to instruct an expert in toxicology. This will be kept under review, At this stage, we can say that Professor Edwin Galea will be considering issues around toxicology insofar as they are within his expertise. A number of BSRs have asked whether there is any evidence of power surges having contributed to the fire in the flat of origin at Grenfell Tower on the night. The position is, as the evidence currently stands, there is nothing to suggest that an electrical surge played any causative role in the cause or spread of the fire. But having said that, the inquiry will continue to review the evidence as it develops. In terms of applications by core participants to rely on their own expert evidence, the position remains that an exceptional case would need to be made out, and any such applications would need to be made promptly as soon as the perceived need for such reports is identified. The inquiry is an inquisitorial process, and independent experts have been instructed by the inquiry so as to provide objective and unvarnished views about matters pertinent to the inquiry's investigations. Unless and until CPs make applications to rely on their own expert evidence, it would be premature to consider any timetable in relation to any other expert evidence. 11th, site visits. Certain CPs have requested access to the building to be arranged by the inquiry. I can only repeat the point I made previously, that the tower remains a crime scene for the time being, and access to it is controlled strictly by the Met. It is likely to remain so until July of this year. We are also aware that there have been a number of safety issues at the tower which have affected the progress of work by the Met. As I said in my Council's Statement number 1 of 15th of November 2017, if any CP would like access to the building, then they should please direct all their requests to the Met and inform us. Miss Clark, who will appear today for the Met, will explain that there is a programme of visits to the tower for bereaved families and for residents. If non-BSR CPs wish to visit the tower once the BSR visits have concluded, then CP requests for visits must come to the chairman so that he can regulate such requests for the purpose of a particular CP's participation in the inquiry. The MPS would then facilitate the visit itself. 12th, written and oral openings. Under Rule 11 of the inquiry rules, the RLR for a CP may make an opening statement at the commencement of the first of any oral hearings. That will be the start of the Phase 1 evidential hearings following the personal portrait hearings. On the footing that the evidential hearings will start on Monday, the 4th of June this year, then all RLRs seeking to make an opening statement at Phase 1 must file with the inquiry a succinct written outline of what they intend to say by email by 4 p.m. on Friday the 18th of May, i.e. 14 days before the evidential hearings begin. All document references must please be accompanied by their URN, their unique reference number, on relativity. All RLRs who have provided a written outline will be invited to make their oral openings to the inquiry during the first week. Those who have not provided a written outline will not be permitted to speak unless the chairman allows it. A draft speaking timetable for opening statements will be circulated by the inquiry team at an appropriate time in advance. We ask the RLRs to be succinct, to cooperate with each other in order to avoid duplication, and to restrict their submissions to the issues in Phase 1. 13th, and finally, order in which the evidence will be presented. It is hard to say at this stage precisely in what order the evidence will be adduced. The chairman intends to be as flexible as possible. Our present thinking is that following the opening statements, we would start by inviting the inquiry experts to make oral and visual presentations of their provisional conclusions thus far, followed in very broad terms by the factual evidence about the flat of origin, then the factual evidence of the firefighters who carried out firefighting and search and rescue, and who made command decisions, as much as possible in chronological order, down to a particular point in the night. Then, the factual evidence of the BSRs, again, as much as possible in chronological order, down to a particular point in the night. And then, any further factual evidence that may be necessary, followed by the expert evidence in the light of all that factual material. I must repeat, no firm decisions have been made or will be made about the order and structure of Phase 1 evidence until we have a sufficient body of BSR witness statement evidence to hand. However, we anticipate that provided we receive enough BSR witness statements on or soon after the end of March, we should be able to present a clear programme for Phase 1 evidence by the end of April at the latest. Mr. Chairman, thank you very much.
Thank you very much, Mr. Millett. Now, Ms. Clark, you're here for the Metropolitan Police Service. Would you like to come and make some submissions? Thank you.
Sir, my name is Amy Clark and I'm instructed by Sarah Winfield of the Metropolitan Police Service, along with Mr. Jeremy Johnson, Queen's Counsel. The Metropolitan Police have not provided any written submissions in advance of today's hearing, but I'm very grateful for the opportunity to outline three broad areas, I hope very briefly. First of all, the police investigation. The Metropolitan Police remain committed to carrying out a meticulous, thorough and fearless investigation in order to identify all of those who may have committed criminal offences and to refer files to the Crown Prosecution Service in due course if appropriate. That process carries with it a great weight of responsibility to the public generally, but of course in particular to those victims of the fire. A number of criminal offences are being investigated and nothing has been excluded from the scope of the investigation, which is progressing. To date, over 5,000 investigative tasks have been generated within the investigation, and data has been gathered thus far from 154 different organisations. We said at the last hearing that the forensic evidential picture about the cause and spread of the fire was not going to be complete until autumn 2018, and that remains the case until the off-site testing and reconstruction work has been completed, and therefore we are currently still working to that timescale, particularly given the scale and complexity of the task at hand. The second broad area, sir, that I'd like to address you on are the arrangements between the inquiry and the Metropolitan Police Service. The inquiry and the Metropolitan Police are, of course, entirely independent from one another, and there is no sense in which the Metropolitan Police is delegating its investigative functions or vice versa. And as we have said previously, the inquiry serves many important functions that the criminal investigation cannot. For example, it will enable a public examination of everything which is in the broad terms of reference. And within that, all core participants, and in particular the bereaved survivors and residents, will be able to take part in that process. And that is something that plainly the criminal investigation cannot fulfil. Conversely, the inquiry cannot make decisions and determinations of criminal liability, and that can only be achieved by a criminal investigation which is followed, if appropriate, by criminal trials. Justice can only be achieved in that regard if the process is able to take place such that any individual or corporation who may have committed a criminal offence is held accountable in an independent and fair investigative and judicial process. So the consequence of the two processes running in tandem is, of course, well known. But in essence, it's that the inquiry will need to make use of evidence that is obtained in the course of the police investigation, but do so in a way that minimises any risk of prejudice to the investigation in the first instance, but also to any future criminal prosecution. That task will be difficult, but so far we are cooperating with the inquiry in a way that we consider to be very productive and helpful to that cause. And I'm very grateful for Mr. Millett's comments early on in his opening statement in respect of the acknowledgement of quite the level of cooperation from the Metropolitan Police and the fact that that will continue long into the future. The MPS has provided material voluntarily on a weekly basis now since September 2017, and so far in excess of 2,000 documents have been provided to the inquiry. In the event that there is ever something that the Metropolitan Police consider cannot be disclosed to the inquiry in the first instance, and that certainly hasn't arisen to date, we will of course notify you, sir, of that extremely promptly. The second stage of the process is, of course, the disclosure onward to core participants once it has been disclosed to the inquiry. And the inquiry has indicated a large number of specific documents that it wishes to provide to core participants for the purpose of Phase 1. And it is right to say that the Metropolitan Police have expressed at certain points some general concerns about the risk of prejudice. And in some instances, as we discussed this morning in relation to statements, we have asked the inquiry to confirm that it considers the provision of particular material necessary to the discharge of its functions. And so, of course, you have done so. And in all of those cases, the Metropolitan Police have confirmed that no formal objection has been raised as to the provision of that material onward to core participants. In taking that approach, the Metropolitan Police seek to facilitate the full disclosure to this inquiry. And we bear in mind at this juncture that none of the core participants whose conduct is being investigated have raised any concerns about that onward disclosure. And that approach, sir, is all within the context of a criminal investigation that is constantly evolving. And last week's public announcement, for example, about the testing of doors brings that into particularly sharp focus. Whilst the investigation is developing, the evidential picture about the cause and spread of the fire will not be complete. And as we have previously said, there is therefore a risk that the evidence will develop further after the Phase 1 hearings have been completed, and that may have some impact on any interim conclusions or reports. And we also reiterate that it is extremely difficult to assess the extent to which the public examination of evidence at this point in the investigation might prejudice future criminal proceedings. And so I highlight this not in the context of making a particular submission or application of any nature, but I simply highlight it in order to remind you, sir, that having both processes running in tandem does present its own risks, and it is a delicate balance to balance both interests. But we are working closely within the terms of the Memorandum of Understanding, and of course will continue to do so. And so far, we have been working together to ensure that any such risks are minimised. Lastly, and most briefly, so I'd like to touch upon access to Grenfell Tower.
Yes.
As Mr. Millett indicated, visits to the tower for those who are bereaved survivors and residents has been arranged through the Metropolitan Police, and that is an ongoing programme of visits that are very carefully planned. And that is happening entirely outside of the inquiry process. And as Mr. Millett quite rightly pointed out, access generally to the tower is restricted by the Metropolitan Police on the basis that it still remains a crime scene, and access will remain so restricted whilst it is a crime scene. The Metropolitan Police have facilitated access to the tower not only for those bereaved survivors and residents, but also for experts that the inquiry has instructed. And in respect of any other visits or any potential visits in the future, The Metropolitan Police are currently reviewing its position about how best to manage that, and we welcome the comments made by Mr Millett earlier this morning about that.
In principle, there's no difficulty in letting people have access by arrangement, is that right?
That's right, sir. That primarily the concern will always be to preserve the evidential integrity of the tower, and that will be managed very carefully on a case-by-case basis. And of course, sir, once you have made any determination that it is necessary for anybody else to have access to the tower. But of course, as ever, we will directly liaise with the inquiry team as and when those matters arise. So those were the three brief points I'd like to address with you this morning.
Well, I'm very grateful to you for coming along. Thank you very
sir.
much indeed. Thank you. Now then, Mr. Friedman, I think you're next to speak if you'd like to. Thank you.
Sir, I appear with Stephanie Barwise, Queen's Counsel, today on behalf of the group of 5 firms, Bat Murphy, Bindmans, Hickman and Rose, Hodge Jones and Allen, and ITN Solicitors. We act for 277 core participants. 62 of them come from bereaved families, relating to now 48 deceased people, of which 10 were children. You have our written submissions. We're grateful for the indication that you've read them. And so this morning, we would like to address you on 2 matters in particular.
Right, thank you.
Firstly, we seek a final ruling that you will answer as best you can the questions of when, where, and how each of the 72 deceased died as part of reasonably discharging the terms of reference, and because this is required to ensure a prompt investigations of these deaths under the Human Rights Act. Secondly, we seek your further direction on the scope of Phase 1, particularly with regard to toxicity, electricity, and what we call the obvious or admitted non-compliance with the building regulations. And on those matters, Ms. Barwise will follow on, please.
Right, thank you.
Can we first turn to the inquest function issue, and we're at paragraph 5 of our submissions. What we mean is that when this inquiry comes in Phase 1 to investigate the cause and spread of the fire, we want you to cover questions of when, where, and how in the building the fire caused the 71 deaths. And to that we add Maria Del Pilla, known as Pilly locally, who is the 72nd victim of the fire, and she died at the end of January this year. We understand that you will also hear a testimonial from her husband, Nicholas Burton, and he's particularly grateful for that. In Phase 2, sir, you can go on to consider the systemic and policy implications of those findings. In substance, that means that by the time you finish reporting, you would have answered all of the questions that an Article 2 inquest would answer under Section 5 of the Coroners and Justice Act 2009, but without you formally being appointed a coroner under Schedule 10 of that Act. Mm-hmm. We say that very outcome is anticipated by the relevant legal framework under the 2009 Act. There is no need to wait to be asked by the Chief Coroner, and if there is no need for everything to be done at once, you must do what you can do now. Mm-hmm. Starting with the legal framework. The inquest proceedings have been deliberately suspended pending the conclusion of a public inquiry under paragraph 5 of Schedule 1 of the 2009 Act. The coroner retains jurisdiction, but paragraph 10 of Schedule 1 means that she will only resume the inquest if in the aftermath of the public inquiry there is sufficient reason to do so. That leaves open the proper role for this inquiry to ensure that there is no such reason, barring new and post-inquiry reporting evidence.
I mean, your point really is that the inquiry, you would say, can and therefore should answer the questions that would have to be asked and answered if it were a coroner.
Quite. And there's been some helpful starting discussions, but it is worthy to remember that there was a time under our law when we couldn't make that submission and you couldn't do it. Because under the previous Coroners Act 1988, this mechanism that we've just spoken about to achieve the humane, effective and expeditious avoidance of overlap between the two procedures did not exist. So it's particularly worthy today for all of us to recall the King's Cross Underground fire of 1987 that led to 31 fatalities. The public inquiry chaired by Desmond Fennell, Queen's Counsel, with a young Ian Burnett and Robert Jay as his counsel to the inquiry, recommended that the duplication involved in holding both a public inquiry and a coroner's inquest should be avoided, and that the government in England should review existing requirements to hold a separate inquest where a public inquiry has been set up, and hence the structure we now have that was always available under Scots law and was incrementally introduced into English law after 1999. Now, Mr. Fennell had found, and I think we've sent this through to you, at chapter 19, paragraph 40, that it, quote, did not seem to me to be in the public interest or in the interest of the bereaved to have two separate public inquiries in cases of this sort. In this way, unnecessary distress to the relatives and witnesses and the inevitable additional expense to the public could be avoided.
Well, you did indeed send that through, and also, I think, extracts from Lord Cullen's report on Piper Alpha. I have you to thank for that as well, I think.
I hope so, because, of course, on Piper Alpha, what Mr. Fennell could not do under English law in 1988, Lord Cullen could do under Scots law when he reported on the Piper Alpha oil rig explosion of the very same year. And he sought, in his words, to comprehend all that involved loss of or danger to life, and again I'm going to quote, from the stage of the initial ignition to the stage when the last survivor reached help. And his chapter 10 dealt with the causes of loss of and danger to life. 167 people had died, 135 bodies were recovered. He gave findings as to the medical causes of death that were ascertainable, adding additional conclusions as to factors which, in his words, contributed to the deaths of the deceased, and otherwise summarised last known movements and whereabouts after the fire began. Appendix H to his report contained information relating to each deceased, including where their bodies were discovered, post-mortem evidence, including toxicology where available, and that concerning inhalation of smoke and or gas were summarised. Not always, but often, the causation results were tragically the same.
Yeah. Can I just say I found the Piper Alpha extracts particularly interesting and helpful. Would I be right in thinking that you would submit that this inquiry should really do what Lord Cullen did, make similar types of findings and so on?
Indeed. I don't want to be pertinent enough to impose the form on you or indeed say that we wouldn't do it slightly differently here, but it gives you an indication of what we're asking for. Yeah. One should just add on this in chapter 10 that you'll see that in the final part he proffered a conclusion about the cause and spread of the fire, again adding pertinently for today that the death toll was considerably higher than it would have been had the instructions been given that personnel should immediately abandon the accommodation and attempt to escape as soon as they could.
Well,
so
it's helpful to know that, because I think Piper Alpha, as you rightly say, gives one a reasonably clear indication of the sort of findings that I think you submit ought to be made in this case. Of course, they're going to be different in many respects, but in substance, the same sort of findings. Is that right?
Yes, and one puts one's feet onto the ground of this inquiry by saying in concrete terms, your team, with the assistance of the core participant legal teams, will need, where possible, to correlate the statements of survivors, firefighters, the 999 calls, and the other available evidence of calls and messages sent to the outside world. This is a 2017 disaster. We have the 2017 technology that wasn't available in 1988. What we're asking for is sensitive work, sir, but it is not difficult if we work together now rather than waiting several years. Sometimes, and it's important to say this, sometimes we don't know, but it may not be possible always to discover with any degree of probability where a given person's last steps were. But at least the bereaved will know that you and we have tried, and of course, it will be less of an ordeal for a family to know that now than to wait several years for that same answer.
Yeah.
Now, you have already declared that there is much force in the proposition that the bereaved should not be made to wait for indeterminate inquest dates several years after the fire in order to discover the fate of the people they grieve for. You posed to us last time two questions. Do the terms of reference permit it? And what would be the procedural implications? And our answers are, yes, they do. And the Inquiry Rules 2006 have been drafted to enable the very job to be done. But just on the terms of reference, and for your note, we're at paragraph 6 of the written submissions, they self-evidently permit the investigation of the inquest-type questions because they ask you at Roman 1 to examine the circumstances surrounding the fire and thereafter at Roman 2 to report your findings. And just pausing there, you may have seen that the terms of reference for both Piper Alpha and King's Cross are to examine the circumstances of the fire and the explosion as the case may be. And so hence those circumstances, we say, could not sensibly exclude an examination of the fate of the people who lost their lives during the fire, and neither could they avoid reflection on how those fatalities might reasonably have been prevented. Sir, how long it took for people to live or die in Grenfell Tower that night is the ultimate measurement of the building's life-threatening features. So too, is it the touchstone to judge the quality of the emergency response? There is then a non-exhaustive list of subparagraphs in the terms of reference, and they're caveated by the word including, and therefore we infer not limited to. And those subparagraphs I'm just going to summarise, but they concern or consider the cause, spread, preventability, and response to the fire. Again, the fate of the principal victims could hardly be removed from their concern. As of today, we are yet to see any public admissions by the council or the various contractors that any features of the refurbishment were causative of the deaths. Surely the inquiry will need to answer that. So not only does the coronial statute anticipate an outcome of you fulfilling its functions to obviate duplication, but the terms of reference permit you to do so. Indeed, as you know, our public law rests on a duty to take account of relevant considerations and equally not to rely on those that are irrelevant. And we submit respectfully it would be unreasonable to pursue the task of investigating the cause and spread of the fire and their emergency response to it, but not to consider the movements of each of the deceased after the start of the fire, the interaction with emergency services and or third parties, the medical cause of death and where available, post-mortem and toxicology. So the task should not be overstated. It is to consider readily ascertainable evidence and then briefly as an inquest to report. The investigation is already underway because your council, through their pro forma questionnaire to survivors, have sought to discover who was where and with whom in the building during the fire. Section 7 of the questionnaire, for those witnesses, asks at question 64, how long did you remain in the flat? If so, on whose advice? And in particular, if it was firefighters, what did they say to you? Question 68, what made you decide to leave your flat? Question 72, was anyone left in your flat when you left? What was the relationship? How did you think they would get out? And then questions 79 to 82 deal with the escape through common parts and then the stairs, including were you alone or with others? If you were with others, who were they? These questions are forensically obvious questions, if I may say so.
Well, and I hope they're all going to be answered, are they?
They will indeed. And when they are, aside from just being questions for lawyers, they're also a compassionate vehicle to chronicle in one place a set of accounts and queries which too many people are presently struggling with alone. There are undoubtedly agonizing gaps in knowledge. For instance, knowing that loved ones walked up 2 floors not down, but not knowing why. Or losing the grip of your child's hand and not knowing what happened next. And then there are, what we understand, terrible twists of fate between those who deliberately ignored the firefighter's advice to stay put and those who did not, whether due to disability or otherwise, and it killed them. We do submit that the inquest-type questions are forensically and rationally connected to the terms of reference. But delay in seeking their answers also exposes the bereaved to unavoidable harm. Anyone, and I do mean anyone, will find it difficult to grieve, to accept the truth of an awful fate until they know what truth actually is. If the answer to their plea, if not now, when, is please wait for the indeterminate date of a coronial inquest, then surely that's an unreasonable answer. It does not sufficiently respect the dignity of their grief and therefore defies both contemporary common law and the Human Rights Act. And that is where we ultimately rest our submission. If one of the core components of the investigatory obligation under Article 2 of the European Convention of Human Rights is to conduct a prompt investigation into the cause and circumstances of a death, then this inquiry, as the chosen public vehicle to investigate the fire, must not abrogate its responsibility under Section 6 of the Human Rights Act to meet that obligation. And our previous written submissions noted the Northern Ireland case of Jordan in 2014. Mr. Justice Stevens held the investigation into the death of a close relative impacts on the next of kin at a fundamental level of human dignity, and he took it to be axiomatic that undue delays in an investigation would cause undue hardship. In the seminal case of Edwards and the United Kingdom, the European Court of Human Rights went on, at paragraph 86, to say that a lack of promptness not only erodes the amount and quality of available evidence, but drags out the ordeal for bereaved family members. And that is the legal principle at stake. It would not have been available to the victims of the King's Cross fire in 1987. But 30 years later, the victims of the Grenfell fire seek its vindication at this inquiry as Parliament intended. Shortly then, on procedural implications to acceding to our request. That answer is in paragraph 8 of our submissions. We make no claim that importing the inquest function into the process would qualify the status of the inquiry rules, including the formality of requiring leave to question under Rule 10.1, and the default principle against repetition in the absence of very good reason under Rule 10.4. We say Rule 10 must be interpreted with a recognition under both the common law and Article 2 that bereaved families will want someone, counsel to the inquiry or their counsel, to ask a relevant question of a survivor, firefighter or third party as to the fate of a deceased person. We as a group of lawyers for the bereaved and survivors will obviously prioritise which one of us on behalf of a particular bereaved family will apply to lead on proposals of questioning. Thereafter, the work will entail combining oral, written and documentary accounts That which is non-disputed and otherwise unnecessary to investigate further can be read into the record, as we'd heard this morning. As to when and how you report, that must be a matter for you. But unlike an inquest, we can address you on the facts, and you could call for written annexes to closing submissions that would assist you in reaching your final conclusions. Can I end my part of the submissions by saying that the application should not be regarded as requiring something somehow unduly onerous or complicated. It doesn't. It's not only humane and required in law, but readily achievable. The inquest questions travel with and are complementary to any sensible narrative of how this fire began and spread. We well understand that the inquiry is concerned to urgently identify dangerous technical practices. My learned friend is just about to address you on some obvious ones. You will want to make remedial recommendations as soon as you can. However, if you and we cast our minds to the Watson Street fire in Glasgow in 1905, up to 39 residents dead, or the Garment Workers Building fire in New York in 1911, 146, mostly women killed, the modern history of terrible fires teaches us that the identification of dangerous practices and amending building regulations will never alone be enough. Change will only come when the political and economic will to make it happen becomes overwhelming, and the inquiry therefore needs to be a cultural event as well as a technical one. If it ends up not telling the chronicle of the deaths foretold, then it will only have told half the story. It will not be the inquiry it was meant to be, and forgive me for pressing one more time, but it will drag out the ordeal and arrest the grief of those who should be its greatest concern. So thank you, and can I hand over to Ms. Bardwise?
Well, thank you very much, Mr. Friedman. Yes, Ms. Bardwise.
Sir, I'm going to deal with the second of our topics and
Yes.
what you have termed the significant degree of flexibility concerning the scope of Phase 1. I should like to briefly touch on three areas. These are toxicity, electricity, and obvious or admitted non-compliance with the building regulations. On toxicity, addressed at paragraph 21 of our submissions, there are two issues. First, the role the toxic fumes played in contributing to deaths, and second, any risk to the life or health of survivors, residents, and firefighters from exposure to toxic fumes during or in the aftermath of the fire. At present, no inquiry expert addresses either matter. Survivors were treated for cyanide poisoning. This strongly suggests the required causal link to examine toxicity for the purposes of the inquest function, should you choose to take it on. But given the link to the wider issues of safety of the building, toxicity ought, in any event, to be firmly within the scope of the inquiry.
Can you just help a bit further? What do you have in mind? I mean, insofar as there were post-mortems done, the pathologists will have tested for various toxic materials in the blood, including hydrogen cyanide, but perhaps more importantly, carbon monoxide. And
Yes.
we will have that evidence. Are you suggesting we should be doing something else?
Well, sir, it is indeed a complicated question. I understand that sometimes one has to give specific instructions to a coroner to test for every possible cause of death. You've identified the principal two, as I understand it, carbon monoxide and hydrogen. But there is an issue about what actually killed them. It won't in all cases have been the carbon monoxide. And obviously, as you'll be aware, sir, the cladding materials contain, we believe, substances which are highly toxic. And therefore it is relevant to consider the issue.
All right. Yes, thank you.
There is the secondary question of toxicity in the atmosphere after the fire, during the fire and after the fire. and it is the burning of those polymeric substances in the cladding materials which give rise to particular source of toxicity. And it's an issue, sir, that we feel should be addressed, both parts of that issue. We welcome that the inquiry will consider the contribution of the gas supply, including incomplete works, to the spread of fire, and has appointed Mr. Rodney Hancox. It was, however, an electrical appliance which appears to have been the immediate cause of a fire in flat 16, and we do ask for the role of electrical systems to be considered in terms of source and spread.
I think you'll find that's going to be done.
Yes, I'm grateful, sir. I appreciate that the inquiry is aware that in May 2013 there was a series of power surges, and we've provided some detail at paragraph 22 of our submissions as to how Grenfell residents experienced those events. And this inevitably begs the question whether a similar surge or similar issues exacerbated the fire in 2017. We're aware that the Tranche 1 disclosure includes a preliminary report which reflects awareness of the issue, but no further expert analysis has yet been obtained. And whilst we welcome that the inquiry will keep this under review, we do suggest that a further report on the subject should be commissioned. The final issue which we submit should also be considered in Phase 1 is any obvious or admitted non-compliance with building regulations. Counsel to the inquiry told us this morning that the compliance questions, as we have called them, namely whether the cladding system and fire safety measures accorded with building regulations will be considered by Barbara Lane within Phase 1. That is most welcome news. I should emphasise we do not seek to have brought into Phase 1 the resolution of which party is responsible for the use of the material, but we do ask that the fact of a product or system's obvious or admitted unsuitability should be recorded by the inquiry within Phase 1. Certain core participants are publicly declaring outside this inquiry that their own products as used at Grenfell Tower patently did not conform to the building regulations. Celotek's position statement confirms to some extent its position taken in the media. Ryden, however, claimed in a press release immediately following the fire, dated the 15th of June 2017, that its work met all building regulations. Yet, its position statement is simply silent on this point. That duality is artificial, runs counter to the victims' and the general public's interest, and should be resolved at the earliest opportunity. Sir, whatever important questions there may be about the building regulations' fitness for purpose, this is not one of them. On a building over 18 metres tall, the insulation material stuck against the external wall of the building to be clad must be of limited combustibility as defined by the regulations. No one has positively suggested to you or in the public domain that any insulation material used on Grenfell Tower complied with that requirement. This particular debate is therefore confined to the question of whether the cladding panels accorded with the regulations. We and the government, as reflected in its Building Safety Programme explanatory note issued following the fire, regard it as clear that on its proper interpretation, approved document B, part 4 of the regulations, paragraphs 12.5 and 12.7, require the core of the panels to also be of limited combustibility on a building over 18 metres tall, and we would expect some other core participants may take the same view. The aluminium composite panel Reynobond PE manufactured by Arconic is not a material of limited combustibility, as is apparent from the original and subsequent British Board of Agreement certificate issued in respect of it. Yep. Arconic's position statement, however, remains silent on this issue. If it is obvious and or accepted by corporate core participants that these materials were not compliant with building regulations, then neither the victims nor the wider public should have to await Phase 2 for the elephant in the room to be called what it is, namely a building improperly enveloped in unsafe materials. Not one of the interested core participants needs more time to establish whether materials complied with the building regulations or not. It would be wholly surprising if they did not already know the answer. If you say now that you will leave the door of phase 1 open to consideration of matters of obvious non-compliance, then the parties can address the issue in their openings, and if they choose not to, then both you and your counsel should do so. Including the compliance questions within phase 1 to the extent possible fulfills one of your own design aims for phase 1, which was the urgent need to find out what aspects of the building's design and construction played a significant role in enabling the disaster to occur. There are two questions. One is what happened, namely how the fire was caused and how did it engulf the building so rapidly. That necessarily entails consideration of how adequate the materials were. The other question is the impact of the regulatory requirements on the adequacy of the materials used. The answers to these questions are not mutually exclusive. Both may entail negative findings, namely that the materials did not conform to building regulations and those regulations are, in some respects, not sufficiently clear. It is, of course, a matter for government and core participants what they choose to say about both these questions and when. It is, however, undoubtedly vital to the victims and the wider public, including the construction industry, that the answers to both these questions should be known sooner rather than later. Those for whom we act are burdened not only by not knowing, but are also plagued by highly conflicting narratives in the media. We invite you to declare the obvious as soon as possible, and then, in phase 2, to establish why it happened. Those are my submissions. Thank you.
Thank you very much. Now, the running sheet suggests you're next, Mr. Mansfield.
Thank you. May I just say by word of introduction that in fact I represent, along with Leslie Thomas, who's going to address you after me. We have divided up the topics, but we, together with, and forgive me if I do this once, I'm not going to do it every time I stand up, is to recite who else is alongside me, but there are a number of barristers as well. I'm going to mention them by name: Alison Munro, Jamie Burton, Justin Bates, Thalia Marat, and Philip Dale. We are instructed by 11 firms. I'm only going to read them again once: Anthony Gold, Bernberg Pierce, Dayton Pierce Glynn, Duncan Lewis, Hanover Bond Law, Hudgels, Janes, Russell Cook, Saunders Law, Saunders Solicitors, Slater and Gordon. I hope they won't mind me reading them rather fast. But however, that's the representational position.
Yes.
But all counsel and all solicitors have obviously combined so far as the survivors and the bereaved and residents are concerned to ensure there's as much cooperation and non-duplication as possible. However, as you've just been addressed on matters which flow into what I would want to address you on, it's principally the question of overlap phase 1 and phase 2. But may I just pick up on toxicity to begin with, because this was a specific matter that I raised in December. And I raised it then because, and I'm sure many people here have visited the scene as you have yourself, there was at the time and persists a concern by people who are still living in the area about the risk, not just to their own health on a longer term basis. And we know from reports that at least 5 individuals have been treated at King's Hospital for cyanide poisoning. That may just unfortunately be the tip of the iceberg, because as you mentioned yourself, carbon monoxide is also another threat, as it were. So it not only to those who lived and survived in the tower and their own personal health, but also those in the walkways and elsewhere. And obviously there will be, hopefully, medical reports from the hospital relating to those who were treated, as well as the post-mortem reports. The problem with the post-mortem reports may be this, that the condition of the deceased that were examined may not provide enough material to make an assessment as to whether there was a toxic element in the death or contributing to the death. So it does require, we would submit at this stage, the instruction of an expert with specific, as it were, instructions to examine the health consequences to the individuals and to the environment. Because people who live there have been saying still live there, been saying that on the night, the product from the burning cladding as well as the insulation could be found a long way from the tower itself. They were picking it up off the ground. And of course, some will be saying, do we get contaminated by merely picking it up? So these are all the issues. They're not difficult to foresee, but we would say this is a separate topic that needs consideration.
Yes.
So I don't say more on that particular aspect. May I turn to the more substantial matter, and that is the position and, in fact, your own observations, which we welcomed after the December submissions that I made about overlap between phase 1 and 2. Simple point that we were putting then and maintain is that it should not become an artificial or hermetically sealed situation. And therefore, may I just for these purposes quote your own words and adopt them. You said this in your later ruling on these matters: having listened to the arguments, I've just done it in synopsis form, I've come to the conclusion that, for the time being at least, it would be sensible to retain a significant degree of flexibility in relation to the scope of the different phases, that in due course it may be sensible to allow phase 1 to flow seamlessly into phase 2 with a minimum of interruption. And then you go on and indicate that it would be sensible, in fact, to include within phase 1, and then you list the issues at 3A, 9A, B, and 8, I think it's H, yes, and H, and 12C. May I develop that for the purposes of what it's about? And I'm really wanting to apply the flexibility approach to the imminent need for certain aspects of this inquiry. And I say it because I hope I'm not being unfair to your own counsel, but I didn't detect, unless it was implicit and I missed it, in the observations and the statement made by counsel this morning, any reference to flexibility. In fact, quite the reverse, because when it came to, for example, and the first dimension of this topic is statements being prepared by the bereaved, the survivors, and the residents. We returned to the phraseology that existed before the last hearing, namely sticking to the narrative of the night. What happened on the night? I don't want to traverse all the arguments as to why we say, yes, of course, that's a good starting point, but it can't be kept to that, because how a fire spread is intrinsically linked to why it spread, and who are going to be in the forefront of being able to at least assist. And I would describe some of them as experts in their own right. That is the people who lived there, who've been in the building for some time before, had been aware of the risks, and on the night were able to identify, as far as they're concerned, what went wrong on the night. So I would ask, first of all, therefore, that when it comes to family, they won't all want to do it. They won't all want to include. But I would ask that consideration is given so that when statements are being drawn up from the, I'm going to call them family members, that they are not, if they don't wish to be, limited to what they may have seen on the night or heard on the night. But if they have observations, I'll put it in that way, about the risks involved, it may relate to the actual materials because they'd noticed what had happened in other incidents like Lakenhall and so on. So they're in a position to indicate what they had been noticing and warning about these matters. and obvious things that were clearly missing on the day, whether it was a matter of compliance or not. There are practical issues that many of them can speak about. Now, as the issues are presently divided, can I just ask you to turn to a couple to demonstrate why we say...
It may help you, Mr. Mansfield, to know that I don't think it's intended to prevent anyone from dealing with whatever he wishes to deal or she wishes to deal with in the statement.
No.
So they don't need to feel that somehow they can't say things that they would like to say.
Well, may I just follow that through? We're very grateful for that indication. But can I just indicate, if you'd be kind enough to look at issue number 5 in the list of issues, and 5A. Now, it's a very obvious question. I'll read it out in case those don't have it in front of them. What were, this is under the heading Fire and Safety Measures Within the Building at the time of the fire. Now, 5A is included in Phase 1. What were the fire resistance, prevention, mitigation, evacuation, and other safety measures, headed fire safety measures, in place at the time of the fire? Now, those are extremely important issues, plainly, but those who are living and may have survived the fire will be, and others who visited the premises, will be in a position to indicate not just what were in place, but what were not in place.
I think that must be
It's an
the
obvious...
case, mustn't it? Yes.
Yes. Well, and I think the families don't want to be in a position whereby, of course, they can put it in the statement, but my next point would be they don't want to have to keep coming back to give their evidence. The point we discussed before, you yourself indicated sympathy for not bringing family members back. So that if on the first occasion, let us say the first week or so of your inquiry, that a family member who's got some pertinent observations about what would have made a difference, whether it's sprinklers on the inside, sprinklers on the outside, all those points, I would submit, not only should they be allowed to say it in the statement, but that you might consider allowing them to say it in Phase 1.
Right.
That's really what it comes to.
Yes.
Now, I won't perhaps labour the point by making the same thing under issue 11, the fire. Same point comes up. However, there are two areas in the issues which I would submit could be added to the list that you yourself made in relation to this, that is, scope. Number 8 on the list of issues is headed Communications with Residents. So once again, but almost explicitly, it is inviting residents to give their observations. And of course, one of the most important ones, again, just an example, is D. What concerns, warnings, and other statements were expressed about the fire safety of Grenfell Tower by its residents or any other person? Extremely important. It's one of the aspects which the United Nations rapporteur recently discerned, is that the residents felt they have been ignored, not listened to, on key issues which would undoubtedly have made a contribution to ensuring that there was no fire in the first place, or at least no spreading fire. And of course, all the other aspects, I don't go through the other aspects of issue 11, so, sorry, not issue 11, of issue 8, that they would have the facility to put it in their statements and additionally to give that evidence before you, if they wish. Not all of them would want to do that. There is another one, which I suggest an issue, which, as it were, bridges the two phases, and that's number 10, response to recommendation. Now, I'm only going to give one example. Obviously, it could be left, but many of the residents, and again, that same group, are anxious to indicate what the response was. And the particular aspect of this is 10B. Were appropriate steps taken by central and local government and other relevant bodies to act upon such recommendations. Now, that's relating to, obviously, other investigations, other inquests, and so on, as well as, clearly, warnings that they've been given by the residents. That could be left, but we suggest again that the residents and that group, residents, bereaved and survivors, will and do have, not all of them, some of them, have observations about how local and central authority basically overlooked the points that they were making. So I'm making it shortly, but I would ask, therefore, that certainly issues 8 and 10 are at least considered for phase 1, because we say you can't separate them out in the way that is otherwise countenanced. Now, this spreads beyond the compilation of statements on behalf of the families. There are 2 other aspects which touch on exactly this issue of ensuring that there is a clear indication right at the start of the inquiry as to where it's going, not just phase 1. Because my learned friend indicated again in the statement that basically the openings were going to be limited to phase 1. Well, that's all right if you have a clear indication of phase 1, but if you're taking a flexible approach to phase 1, which we would submit is absolutely necessary, then the openings, for example, on behalf of these groups, would have to, we say, include, in fairness to everyone, not just the core participants who are residents and so forth, but core participants who may be in some way or another responsible. And we have now position statements. And it would be, again, a travesty not to be able to refer to position statements in the opening of the whole of the inquiry, although it's the phase 1 of the inquiry. If they're going to, as it were, as you've put it in that judgment, there's going to be a seamless flow from one to the other, and there are going to be clear overlap areas, then what the issues are, namely what was missing, what went wrong, and who is the person or organisation responsible for the failure, whether it's a non-compliance or whether it's an actual item that is not provided. I think on the last occasion I mentioned hose reels. They're very simple points, but to divide it up between what was or wasn't there on the night to, well, we'll later discover who failed to either put it there or make it ineffective for a later time, we said would be diluting the accountability issue. Because one of the investigative and inquest questions is accountability, is being able to identify those responsible. So I don't take that longer other than to say, we say this impacts on the openings, and the openings should be able to embrace the bigger, as it were, tapestry of what's happened in this case, not limited to what happened on the night. This also affects a third issue, and that's experts. We've given an illustration, so I'm not going to repeat it. It's in the submissions we've made. You will find this in paragraph 23, that experts, we say, and that this is imminent, as we gather expert reports may be available within the month, that expert reports also are not artificially divided between the 2 phases where there's a clear relationship between the 2. Because when witnesses start to give evidence, it's important that we all have an idea of what it is that we're, as it were, aiming for. What are the targets here? What are the target issues? What happened on the night, yes, is the focal point, but arising out of that, almost like a wheel, are going to be spokes going in many directions. And everybody needs to know which direction they're going and what are the key aspects of the failures in practice and the non-compliance, rather than leaving it for later, because then you miss at the factual stage what it is you would have asked had you known that actually it makes a great difference. Well, I'll give an example. It's just come up last week, and that is the Met Police have issued apparently they've issued a report about fire doors. that the fire doors were not resistant for long enough and only 15 minutes. Well, that's the kind of issue. You need to know all that. Not what happened, but what didn't happen and what would have made a difference. All becomes, as it were, elided into one issue. So I think we make the point very clearly. So we would ask for expert reports to certainly be prepared with that in mind. And I come finally, I'm sorry, I hope I'm not overrunning too much. The site visit was the third topic I was going to raise.
Yes.
Perhaps I don't need to
Have
spend...
you been reassured about that?
I think so.
Yeah, I mean,
I'm going to turn up tomorrow and find out what happens.
Well, if you've got an appointment to be there,
Yes,
I'm sure you'll be well
yes.
looked after.
I mean, as with many others, I've been down many times, but I've never managed to get into the tower.
Yeah.
But as long as the Metropolitan Police are prepared and managed, and we're quite happy to be managed, but as long as it could happen before the opening of the inquiry, that we could get to see. That is, so I can't speak on behalf of all lawyers, they may not want to go, but on behalf of the legal representatives, I understand the families can go under the programme, so that's not a problem. So I don't take it any further.
Thank you very much. Right, now, Mr. Thomas, are you going to speak as well on behalf of your clients? Your turn then.
Good afternoon, sir.
Good afternoon.
So I'm dealing with generally two specific topics, and I hope to be brief. Can I just deal firstly with the topic of experts? And this is just really to supplement what has already been said and to assist your inquiry team with some of the issues that we have in mind are concerned about. And the first is this. Firstly, we thank you for the provision of fundings that you've provided to allow us to instruct some experts. That really does assist, particularly in terms of levelling the playing fields in terms of equality of arms. So we thank you for that. But to make that really and truly effective, the timetabling, and I know that we're working under a tight timetable for good reasons, but the timetabling needs to be just thought about just a little bit more. And let me give you a couple of examples. You have set a timetable in relation for when we are going to be receiving the expert reports that you have instructed. There needs to be inserted into that time for the experts that we instruct, time for them to digest it, and also it needs to be thought about very carefully when that expert evidence, your expert evidence, is given and when our expert evidence is likely to be given thereafter. Okay, and I'll explain what I mean. When I say our expert evidence to be given, should an application be made in accordance with what was said earlier on? And what I mean is this. Firstly, for our expert evidence to have real understanding, our experts will firstly need, if they so wish, access to the site. That must follow. And secondly, access to any physical exhibits that other experts have seen. So that just needs to be factored in.
Yeah.
We would wish to reserve our opinion on the timing of the position on the hearing of expert evidence, factoring in an opportunity for our experts to consider that evidence, because we haven't got it yet, and we can't say until our experts have seen.
I understand that, yeah.
So I'm glad that makes sense. So that's all I want to say in relation to the experts. They're short points, but I hope understandable points. Can I turn then to the personal portraits or pen portraits, however you want to describe them? And secondly, can I thank your counsel for making contact with me in relation to what's being proposed? I think a lot of ground has been made in relation to this.
We've pretty well got an agreed arrangement, haven't we?
More or less.
And conversations between council may be
help.
a more fruitful way of taking
Absolutely.
it forward.
Absolutely. I'm not going to be long. Can I just take this opportunity to emphasise, and I know that you understand this and get this, but just in relation to just how important these pen portraits are. And I know that this is being televised, as it were, live, and so some may not understand the significance of pen portraits and what they mean. The pen portraits of the bereaved, not just the bereaved, the loss of the community in which Grenfell Tower represents, is nothing less than a testimonial to the dead, a sketch of who they were, where they lived, their connection to the tower, their contribution to the local community. And what we want to achieve is done so that when the inquiry, when you, sir, come to hear the evidence, that evidence can be put in its proper context. This is not because what is being sought is sympathy, but more empathy, so that you know the people who are being referred to. They are not just another statistic, not just another number, not just another dead person. We are dealing with real people who had real lives, who've suffered real loss, and who are in real pain. And so, sir, and I know that Mr. Millett touched upon this when he addressed you this morning, but there are one or two things that are really important when you come to hear this really sensitive, and if I may say so, at times delicate evidence. Mm-hmm. There will be issues of translation. There will be much distress. We will need to take into account cultural differences in terms of people trying to express themselves and trying to express themselves in a way that at times may seem upsetting for them, upsetting for others listening. And there really needs to be real cultural sensitivity when that evidence is being heard, bearing in mind that the tower was a real melting pot of different cultures, races, religions, all coming together. Therefore, sir, the timing and taking of these portraits is a sensitive matter, and we are really heartened by what your council, what your team is doing and communicating to us in relation to how that evidence is to be taken. Finally, may I say this? We would like your team and you, sir, to also bear in mind that in the taking of these pen portraits, the inquiry must also consider the wider suffering. There are many people from the community who were not residents, but who shared the profound grief, sense of loss of those who lived within the tower. There are going to be some people from the walk who are also core participants. They have had their lives shaken to the core. They were terrified. They watched friends, neighbours die. And even these individuals have the right to be able to stand up and say how this has devastated their lives and what it means to them. So I know that there will be flexibility, so you've indicated that. In terms of that flexibility, all we ask is when these pen portraits, they're not going to be narrowly constrained. I have had discussions with your council in relation to the timetabling of it,
Right.
and so I don't need to trouble you with that. Thank you for listening to me.
Well, thank you very much for your submissions. Yes, Mr. Weatherby, you're next.
Yes, thank you, sir. Together with Sam Steen, I lead Fiona Murphy and Mark Henderson for approximately 150 bereaved and survivor core participants, instructed by Jangir Mahmood from Bishop Lloyd Jackson, Martin Howe from Howe & Co, and Arfan Bhatti from Oliver Fisher. Can I say that I'll be addressing, as briefly as I can, three topics which I have dealt with before, but there is further discussion which we submit would be profitable to all. And can I also start by saying, perhaps stating the obvious, that for the bereaved and the survivors, they're as keen as anybody else, indeed keener than anybody else, that this process should move on as quickly as possible and as cooperatively as possible in order to get to the result that we all hope to achieve. And can I say that we are grateful to Mr. Millett for the comments that he's made this morning, and indeed through the informal contact that we've had with him and his team previously. And we don't doubt that your team are working very hard indeed. And we don't doubt that the matters that they're dealing with in this public inquiry are both very major and very complex tasks. Of course, there's a but coming. The but is the matters that I'm going to talk to in the next few minutes, and they are essentially around disclosure. But to get there, I want to touch upon what effective participation by the bereaved and survivors looks like, or should look like. And also I want to return to the issue of position statements. The reality is, the fact is, as we stand here today, that we have had only 1,962 documents disclosed to us. Mostly individual photographs of the building or the inside of the building. Out of the 330,000 documents that the inquiry has gathered to date. And that means that the disclosure to date is just over 0.5% of the material that the inquiry team has. And that doesn't include the massive material that the Met has. And that does concern us.
And I'm sure you understand a lot of that material is probably not going to be particularly relevant to phase one and the immediate questions. We
do understand that. A lot of that material will be irrelevant to phase one and phase two. Some of it will be duplicative, some of it will be more relevant to one phase than the other. But having said that, when I come to the list of matters that we are concerned about, a lot of it, or a significant amount of it, and we don't know what, because we don't know what it is, but there must be a significant amount of documentation that needs to be disclosed. And we are here 2 months away from the starting date for phase one, and that's what concerns us. Let me touch on, as an example, and I'll come back to it in due course, but the material that was supplied to the experts There are 9 experts, as we understand it, currently instructed by the inquiry. And we have not had disclosed to us the material that must have been given to them, or 7 of them indeed, some 4 months ago. And whereas we've heard this morning that the Met may wish to have some input into that, we simply don't understand why that material, which must have gone through the potential relevance test and must be in a form to be provided to experts, why that sort of material could not be supplied to CPs more generally.
One explanation may be that it's not the sort of material which is easy to assimilate or digest without the benefit of the expert report which will come with it.
Well,
you may say that's not a good reason, I don't know.
Well, I'm grateful for that indication, but I'm slightly alarmed by it as well, because if disclosure is going to be made on the basis that we will not understand it, then the disclosure throughout this process is going to be extremely problematic. I earlier made a submission, I repeat it now, that the only way, with respect for disclosure to be made, is in tranches as it's considered, and not to be over concerned about which part of the inquiry it relates to. Because if that happens, then it becomes so intertwined, disclosure will not be made. Well, if that is the plan, then we would very much urge that you revisit that. We're in a position where we are going to have to assimilate and work a large amount of documentation for a large number of experts dealing with very complicated matters, starting in perhaps 2.5 months' time. Also, as Mr. Thomas has just referred to, we're going to have to instruct our own experts to consider, at least in part, some of that. And therefore, the earliest disclosure that could be made would have greatly aided that part of the process. Without effective disclosure, it puts us in a position where our clients, bereaved and survivor CPs, are simply not going to be in a position to effectively participate, or their effective participation in this whole process is going to be severely diminished. And it seems, taking again where we started with the disclosure of the expert, the material provided to the experts, with respect, once it's passed the relevance test and there are no particular objections to its disclosure, then there seems to be no advantage to the inquiry to hold it back pending the reports itself. May I then follow again what are probably quite straightforward submissions about effective participation, and we've set them out again in our written submissions.
Yes.
There have been repeated assertions through the past months that it's for the inquiry to investigate rather than for core participants. In the written response to the first preliminary hearing, there was reference a number of times, and I'm quoting, to the wish of core participants to monitor the work of the inquiry and looking for reassurance that the inquiry is doing its job properly. I don't think those are words that I used, or indeed other core participant representatives. Let me develop this in 2 very short submissions. Firstly, not only do we agree, but we indeed emphasise that it's for the inquiry to investigate. Both under domestic and convention law, it's crystal clear that the inquiry is under such a legal duty to conduct an independent and a thorough investigation. Any failure to seize or gather relevant information or evidence and testimony, a failure to pursue rigorously lines of investigation, or a failure to pursue accountability would be a breach of those obligations, and in particular a breach of Article 2. So no argument from us that the legal responsibility for a full and effective inquiry lies on the public inquiry itself. However, there is a further legal obligation on the inquiry in that it has to facilitate effective participation by the bereaved and the survivors. And once again, this is a complementary legal obligation on the inquiry, articulated in the cases which are well known and referred to in our written material, particularly from Jordan. The requirements of effective participation are not well developed in the case law, but that's because what constitutes effective participation will differ from inquiry or case to case. But in our submission, in an inquiry such as this into a major public disaster with such loss of life, the requirements of effective participation go far beyond monitoring or being reassured about what the inquiry is doing. And in the domestic case law in particular, the higher courts have regularly referred to the requirement that the bereaved are properly represented, but also that they're provided with all relevant material. And I read into that all relevant material expeditiously. And we referred in the written submissions to Armin Humberstone, and in particular Smith and Oxford coroner, and the words of Lord Justice Sullivan in the Bentley case, and I'm quoting, "In an Article 2 case, it will be difficult to justify any refusal to disclose relevant material." And again, I add the word expeditiously. Now, putting together those two parts, the obligation to investigate unequivocally on the inquiry, but that does not, given effective participation, mean that the inquiry should take some kind of paternalistic approach, to leave it to the inquiry to investigate everything, or indeed to manage the disclosure in the way, with respect, that has just been indicated. Effective participation requires involvement. It requires the right to make meaningful submissions regarding lines of inquiry. It requires the right to transparency of the process. It may include the opportunity to question witnesses. And underpinning all of those parts of effective participation is the need for full disclosure at an early stage in order to allow core participants to engage with that process. Staying with the expert disclosure matter, how can we make proper informed submissions about what the experts should be looking at? How can we, for the bereaved and survivor core participants, point out other areas, other lines of questioning, unless we have the underlying material? And how can we properly instruct our advisory experts without that material? To allied effective participation with reassurance and monitoring, and the fact that the inquiry itself is doing a good job, is, we would say, a fundamental error. Position statements. At paragraph 41 of your response to the first hearing, you indicated that it would be helpful to everyone involved in the inquiry that the corporate and public authority CPs provide position statements, and requested them by the 9th of February. And that approach had followed submissions from the bereaved and survivor representatives, which were happily met with almost universal agreement by the corporate and public authority representatives. However, as you pointed out in your response, what we had submitted and what the corporate CPs had agreed to were not one and the same thing. Nevertheless, the request for position statements we viewed as a very positive move by the inquiry. And having seen recently, having seen the position statements, or at least most of them, because there was some delay in providing them to us. We can see that they will very much assist the process and reduce the work of the inquiry and everybody, including us, in understanding how each of the organisations interact. However, having said that, to describe them properly as position statements may be going a little too far, because virtually all of the position statements so filed have constituted more of the version offered by the corporate participants rather than what we were submitting should be requested from them. And the difference is perhaps best considered by posing the question, what is the aim of position statements? And the aim of position statements we would submit I hope that's not a guillotine.
May I have your attention, please? May I have your attention, please? Fire has been reported in the building. This report is being investigated. Please remain at your workplace whilst the fire alert exists.
Mr. Weatherby, I think for the moment we should stay where we are. And you carry on if you're happy to do so.
I'm conscious of the bereaved and survivors' position given such a warning.
Well, if you'd rather rise, we can do that.
I'm afraid I think it would be appropriate.
Yep, all right. Well, we'll rise now. Would it be sensible to break now and get something to eat rather than come back in 20 minutes and break again?
I'm entirely in your hands.
1:30 then, please.
May I have your attention, please? May I have your attention, please?